Will Senate please come to order? In lieu of a devotional, we will have a moment of silence. Thank you. Are there any announcements? Seeing none, we have bills for introduction. S55, an act relating to reference-based pricing for hospital services, introduced by Senators Hardy and Gulick. Please listen to the first reading.
S55, an act relating to reference-based pricing for hospital services.
Now you've heard the first reading, and the bill is referred to the Committee on Health and Welfare. S56, an act related to creating an Office of New Americans, introduced by Senator Gulick and others. Please listen to the first reading.
S56, an act relating to creating a new office of an Office of New Americans.
Now you've heard the first reading, and it is referred to the Committee on Government Operations. S57, an act relating to the Standard Offer Program, introduced by Senator Watson and others. Please listen to the first reading.
S57, an act relating to the Standard Offer Program.
Now you've heard the first reading, and the bill is referred to the Committee on Natural Resources and Energy. Orders of the day. S9, an act relating to after-hours access to orders against sexual harassment. We have on the calendar for action S9, introduced on January 15th, 2025. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as it appears in pages 21 and 22 of today's calendar, and that when so amended, the bill ought to pass. Now listen to the second reading of the bill.
S9, an act relating to after-hours access to orders against sexual assault.
For the report of the committee, the senator from Franklin.
Thank you, Mr. President. S9 refers to these are civil court orders requested directly by a victim, aka plaintiff, for protection. It assures important protective measures, including requiring a perpetrator to maintain physical distance from a survivor, stopping contact with a survivor, or other means necessary for a survivor's safety. Lack of after-hours access to sexual assault orders is particularly concerning in environments where a survivor is in close proximity to the perpetrator, such as a college campus or an apartment building. Advocates of the Network Against Domestic and Sexual Violence members organizations who support 24/7 support for survivors consistently report survivors' safety is compromised when they cannot seek a sexual assault protection order after hours. And now on to the bill. The purpose of S9 is to allow a person to obtain an emergency protection order after sexual assault outside of regular court hours in the same manner that emergency domestic violence orders are obtained currently. In 2006, the legislature established a process where a person who was alleged to have been subjected to a stalking or sexual assault could obtain a civil order of protection if they were not eligible to obtain a domestic violence order because the alleged perpetrator was not a family or household member. Issuance of these orders is a civil process that is separate from any criminal investigation or prosecution that may also occur. Example, a UVM student is sexually assaulted on a Friday night. A report is made to law enforcement. The survivor, the plaintiff, may petition for a protection order that directs the defendant to stay away from the plaintiff or plaintiff's children, or both, and may make an other order it deems necessary to protect the plaintiff or the plaintiff's children, or both. A criminal charge against the defendant is not necessary to obtain the civil order protection. The standard for determining whether the order is issued is a preponderance of the evidence, which is 51%. These statutes are modeled after the domestic violence orders and allow a person to obtain a temporary emergency protection order that is valid for 10 days until a final hearing can be held regarding a final order. Currently, the emergency orders against stalking or sexual assault cannot be obtained on nights, weekends, or holidays, such as domestic violence orders presently can be. This amendment extends the ability to obtain emergency orders against sexual assaults, but not orders against stalking on nights and weekends. The reason for limiting it to sexual assault are because the numbers of petitions for the stalking orders in 2024 were 1,354, which is significant compared to the number of sexual assault protection orders, which was roughly 32 in 2024. And victim rights organizations said at this time they were only seeking the added hours for sexual assault orders. Turning to the amendment, Section 112 VSA, statute annotated B2, directs the court administrator to establish procedures to ensure access to orders against sexual assault after regular court hours or on weekends and holidays. The court is to designate an authorized person to receive requests for such submitted after regular court hours, including requests made by a reliable electronic means. If a secure setting is not available for processing the order after regular court hours, or if the authorized person determines the electronic submission is appropriate under the circumstances, the authorized person is to inform the applicant that a complaint and affidavit may be submitted electronically. The affidavit may be sworn to or affirmed by administration of the oath over the telephone. The authorized person will communicate the contents of the complaint and affidavit to a judicial officer telephonically or by reliable electronic means. Then the judicial officer will decide whether to grant or deny the complaint and issue the order on the basis of the contents of the affidavit. The judicial officer will communicate the decision to the authorized person, who will communicate it to the applicant. If the order is issued, it will be delivered to the appropriate law enforcement agency for service and to the holding station. Section 2 establishes an effective date of September 1, 2025. This is to allow the court to establish the procedures and staffing necessary to implement the policy changes made in this bill. Senate Judiciary heard from VRP Project Director, Vermont Legal Aid, Team Lead Legislative Counsel, Office of Legislative Counsel, Lieutenant, Department of Public Safety, Director of Policy, Vermont Network Against Domestic and Sexual Violence, sponsor of the bill, Addison District, Deputy Defender General and Juvenile Defender General, Defender General's Office, and the Chief Superior Judge, Vermont Judiciary. The vote came out of Senate Judiciary 5-0-0. Mr. President, your hardworking Judiciary Committee asked for the Senate support. Thank you.
The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Senator from Addison.
Thank you, Mr. President. I just rise on a point of gratitude for the chair of the Judiciary Committee and the entire Judiciary Committee for taking this bill up so early in the session and moving it forward. We introduced this bill last year and there were some technical issues with it. And so I worked in the off session with the Chief Superior Judge and the network to get to language that everyone could agree on. This is super important for many people throughout our state who are victims of sexual assault and puts them on an even playing field, so to speak, with people who are victims of domestic assault. So I just want to thank the committee for taking it up. It will make people feel safer, particularly people who live in congregate settings. So thank you to the Judiciary Committee.
Are you ready for the question? The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? If you're ready for the question, all those in favor, please say aye. Aye. All those opposed, nay. The ayes have it. And you have amended the bill as recommended by the Committee on Judiciary. Now, the question is, shall the bill be read a third time? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of S9. That completes the orders of the day. Senator from Chittenden.
Thank you, Mr. President. Pending announcements, I would move that the Senate stand in adjournment until 9:30 a.m. Tuesday, February 11th. And if I might lead off the announcements, and if I might ask for permission to read from a text that I received from our Senate Secretary. I know we are all concerned for his health. He is on the mend, and he sends the following. If you've ever texted with him, you know that he writes sort of like poetic lines, doesn't let it wrap around. He sort of breaks them off, so I will read it as his poem. Sorry for the extended absence, feeling better, been keeping fever down, returning next week to provide consequences for all the misbehavior of the past. Thank you.
Thank you. Senator from Chittenden.
May I rise as a point of personal privilege?
Yes.
In the house today were a bunch of dogs, and I just want to say why I'm wearing a UVM cat or UVM tie is because the UVM men's soccer team was in the building, and I know we don't do any of those recognitions and so on, but I just want to say that's why I'm wearing the tie today, because those dogs made this old catamount real proud. Thank you, Mr. President.
Are there any announcements? Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1:30.
Senator from Washington.
Thank you, Mr. President. Senate Appropriations will meet at 1 o'clock.
Senator from Rutland.
Mr. President, Senate Government Operations will meet at 1.
Senator from Windham.
Thank you, Mr. President. Senate institutions will be will be on the road today. We will start in the committee room at 1, and some of us will be going to the Southern State Correctional Facility today. Thank
I
you.
hope they let you out. Are there any more announcements? Seeing none, the senator from Chittenden has moved that we adjourn until 9:30 a.m. Tuesday, February 11th. All those in favor, please say aye. Aye. All those opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it, and we've adjourned till 9:30 Tuesday, February the 11th.